Good afternoon, Judge Phatudi.
Good afternoon, DCJ.
How are you?
I'm surviving. I'm fine, thank you.
Are you the eldest in your family?
No.
No, I ask because you have so many names, and that usually happens with firstborn children. Everybody wants to have a go.
No, I'm the last. I'm the 8th child of the late Reverend and Mrs. E.M. Phatudi.
Well,
By right, I'm the 10th child born, but the two other siblings passed on at their early stages, and our parents always said that we are only 8, 4 boys and 4 girls, so I'm the last one.
so you made up for all that pain.
Yes.
You hold 2 degrees and a BU recent and LLB from the University of the North.
Correct, ma'am.
That's TEFLOP.
That's
Can't
Teflop.
get used to these new names.
University of the North, Teflop.
And you came from the sidebar before you became a judge.
Yes.
How long did you practice as an attorney?
About 13 years as an attorney.
Yeah, you started your own practice in 1996 and ran it until 2008.
Correct, that was my only practice, practicing my own account, yes.
You started your judicial career in Pretoria, in JP Mlambo's division.
I started the judicial career at Johannesburg, the Gauteng
Or in
division.
Johannesburg?
Yes,
Well,
Johannesburg.
that's not
That's
what
where
your questionnaire says.
my first acting stint was in Johannesburg, and then from there went to Pretoria, and in 2009, 1st of February, then I was appointed, or I took permanent appointment.
I'm sorry, your voice is a bit soft.
Pardon?
Just bring the mic closer to you and... Okay, have a go again.
No, I said my first acting stint
Was in Johannesburg.
was in Johannesburg, yes.
All right.
Yes.
And you transferred to Limpopo in 2016.
In 2016, I transferred from Pretoria, then I went to Limpopo.
All right. So you have been a judge for how many years now? I'm sorry, it's late in the day and my arithmetic is not good at the best of times.
I think it's 13
been a
years.
while.
13 years of permanent.
All right. Have you managed to produce reported judgments
Yes.
during your stint as a judge?
Yes, I did during my stint as a judge. The one from Johannesburg, I think there's one in, almost 6 or 7 in when I was in Pretoria. And then the other one is when I was here in Limpopo division. Yes.
Well, you mentioned in your application form that you have produced about 2,041 written judgments, although only some of them are reported.
No,
Is that number correct?
the number is not correct because when you are in Pretoria, that's the division that is very hectic. And we were then even dealing with the opposed motion. I remember at some stage I was even chairing the committee of the opposed motion in Pretoria, where as a kind of senior judge, you would then be given almost 50 opposed motion files, which you had to deal with and to allocate to the other 4 judges.
Wow, that is a tremendous volume of work.
Yes, so
Yeah.
quite a number of judgments would then be coming from that very particular point. But some were not reportable, quite some, because of the volume, We were even
Yeah.
tempted to do the extempore at that very particular.
Yeah.
But that in itself would have been a judgment as well.
All right.
Yes.
And you, well, at least when you submitted this form, you had no reserve judgments.
No, I never had reserve judgments for more than 3 months.
Okay. You want to take over from JP Makgoba when he leaves. You want to be the judge president of the Limpopo division.
Yes,
And you are vying for that post along with 2 other of your other colleagues.
correct.
Why should we choose you over them?
Well, firstly, I have a vision that I have, and I've prepared kind of to say the vision that which I have is
Let's hear it.
pardon?
Let us hear it.
Is the vision in me and is the vision with me. And that vision basically, as the point of departure, I said the state of Limpopo division, how it is. Firstly, it is constituted by the 3 divisions. It is the main in Polokwane and the 2 local divisions, the one in Tohayando and the one in Lephalale. And all these have been proclaimed by the proclamation and gazetted, I think it's number 39601 of 15 January of 2016, which was effective on the 25th of January 2016. Now, the manner in which these divisions are, it's the main in Polokwane has the concurrent jurisdiction for both. And the divisions at Polokwane and Thohoyandou are the 2 with the stand-alone building structures. Well, there are infrastructural challenges at both the Polokwane and the Thohoyandou buildings. The Polokwane main, the new as it might be, well, it has quite a number of challenges, structural challenges, for which I don't intend to go through one by one. But those challenges might need some attention, otherwise it might as well be turned into a white elephant. And the Thohoyandou building, it's an old building, which was used by the then Venda, or the Republic of Venda, which was the Venda High Court. And when democracy kicked in, it then been taken over. It functioned as Gauteng division, functioning there as the Thohoyandou, up until it was proclaimed. But the building structures there are 3 chambers, judges' chambers in there, and the 3 courtrooms, which accommodate the 3 judges there. The said accommodation structure further accommodates the Director of Public Prosecution, we've got the state attorneys, and the Office of the Master.
In the same building?
In the same building. It's only some sections but we all at some point would meet at the corridors of that very same building, especially with the DPPs, even when walking into the courtrooms, and if I were to walk to the chambers of my other brothers who might be there, I might bump against them on the corridors with or even without the witnesses or prospective witnesses. So the renovations at the said Thohoyandou court requires quite a number of determination. There were quite a number of reports that have been prepared. The ones that I've seen with my, about 3. The first one, it was even declared that no human being should be in that building within a month's time. But that report, I think, was set aside, and another one came and says, no, Renovations may do well here and there. And the third one was that some of the staff members would need to be moved probably to some other areas like Sibasa, that's a regional court, and the magistrates court, or the magistrates court in Thohoyandou. But as we stand as of now, that's how it is. That's the last report that which I've seen. I've heard that it be submitted to the office of the minister at the time.
And you've all remained in that same building
We
through
remain
all
in-
those reports?
We remain in that same building. It has even been guarded with fire. My chamber was one of those that caught fire. Fortunately, I was not in the office at the time. I was on long leave, but it caught fire. We took some time, probably 3 weeks or 4, while waiting for it to be cleaned, for one to can continue using the said building and the courtroom. Now, that's basically the structure that which we have. But the Lipalale, we don't have any infrastructure other than to rely on the magistrates court building that it's there in Lephalale. And the last time that I visited Lephalale, we were using a chamber used by the regional court. It's a one chamber with one court. And if we are there, then it would mean that the regional magistrate will have to move to the other division. Probably the magistrate would then go to, not the second, yes, the way as they call. Then it means that we as the High Court will then be pushing out the regional court will push out the magistrates court into them. And there were some movable tin houses that which were then brought to the Lipalale with the view that some of the staff members would be using the said tin house. But I haven't been there because I'm always to be in court, and it's during the week. During weekends, there's no way in which I would find any there to can verify how the state of the building is at. But proclaimed as it is, members of the community in that area need services. That is, justice must be taken to the said people because they will be traveling, if my memory serves me well, subject to correction, is that they are traveling about 250 kilometers a single trip from Lephalale coming down to Polokwane Court for their matters to be heard. And going back, that will be another 250 kilometers. Now, when I'm appointed as the JP and taking the baton from JP Makoba, I intend to do what I call a visible leadership, meaning that I would have an office, say in Thohoyandou, not a chamber per se, but just an office for one to work in it and leave the other 3 chambers for 3 judges and still share it with the Polokwane, and at some point if infrastructure or an alternative structure that can be used for implementation and taking the services, the justice services to Lephalale, then we would then have to improvise and see how we can deal with it. Perhaps when proclaimed, at the time when I was the acting deputy judge president, I had an opportunity of being invited by the Judge President Makuba to join him in the meeting with the minister and dealing with the very issue of Lephalale and how to deal with. Much as I shared the sentiment of, at the present moment, because of no infrastructure, then the unfortunate part is the people of Lephalale would have to travel to come to Polokwane for their matters to be heard. That would be the civil matters. The criminal matters, the Judge President more often would then create a circuit court and send one of the judges to deal with the criminal cases that may emanate from that very particular area. So, as I'm saying that the leadership that which I intend implementing would be that to be there, even though it might not be on a daily basis at all the divisions, but at least once in a week on both the divisions, or even Lephalale to can as well have that. Now, there is the issue of the access to justice, because we want the people who are staying in that area of the world of Lephalale to as well enjoy the access to justice, rather than for them to spend 250 or to travel 250 kilometers single trip. And at times with these load sheddings and the way as the support system might fail, you might find that it says, load shedding, there's nothing you can do, the roll is locked, we are bound to postpone some of these matters. You imagine a litigant traveling back home without that matter. I'm saying this because to date, as we speak, subject to correction, the Polokwane main division, we are now issuing the 10,500, meaning that the case number as it might be issued today, it might be 10,500, if not 10,400, then 90, whatever odd. But I just rounded the figure to say it's 10,500. And the waiting time for the opposed motion, as of now, the dates being given and to the litigants is August 2023. The unopposed, well, still a little bit fine, but it says January 2023. That is, the entire term is a waiting time with the unopposed. And the civil trials, well, it says October 2023. That is the last case being allocated a date is that of October 2023. And the waiting time for the Thohoyandou local division, the opposed motion, it's September 2023. The unopposed, 3rd November 2022, but the civil trials, it says February 2024. And the reason for it is we do have a number of special civil trials, which are the ones that the last given date was that of February 2024. So litigants whose matters are to be heard in 2023 and 2024 may perceive such a waiting period as probably, in my quotes, I say it's access delayed, might be seen as access denied. There is the need for or to develop a better strategy. One of those might be modernization of courts, digitalization of court records, the visual hearings, the e-filing, courts online, mediation, and in my view, those might or I view them as better strategies. Perhaps just to add up on the visual hearings and the way as I intend implementing it. It's for us to bring back the civil trials from February 2024. It would mean that instead of one of the judge doing the civil, will do all the civil work, meaning unopposed, opposed, pre-trial, case management. It might, in my view, the way as I intend implementing would be all these other matters like the unopposed, the case management might be done by way of visual hearing, and the other courtroom and the other judge will then be dealing with only these trials, civil trials, so as to can bring back the waiting time from February 2024, and most likely because those trials, according to the list I have seen, there are about 12 civil trials, 7 of which come from one single firm of attorneys, and they are the medical negligence cases, and they require 4 to 5 days to be heard. And if one judge would specifically be allocated to deal with such cases a week and in alternate with other judges regarding to that, then these other matters, probably to a certain extent, the opposed motions, because in opposed motions, that's where the parties only rely on the papers that are before court. And well, they stand and fall by the papers that are there, as opposed to a civil trial where a witness needs to take a stand and under oath and be seen at that very particular time. Now, the challenge is if one is to implement the visual hearings, of which I, at this point in time, have started, or I had quite some few or a number of cases using the very method of visual hearing. But most of those were the opposed motions. But the challenges that one encountered was, one, that the registrars at Toronto were not at faith with the system, did not even understand, well, the computer in itself. Secondly, when dealing with urgent applications, especially the ones that are brought at night, I would normally do them by way of visual, because some of the registrars come from the area beyond Mutale area, which is about 70 to 75 kilometers away from the courtroom. If they were to come to the courtroom to attend for the issuing of the processes and being at night, for them to go back home at that very particular time, it becomes a bit unsafe for them to do, meaning that the security of such court officials is at stake. But the other challenge that the registrars informed me of is that they are not provided with the laptops, like the clerks for the judges' register. Clerks do have the laptops, but the registrars do not have the laptops. And that being a challenge for them, and say if they as well could be probably be afforded either one, laptop which can rotate among themselves when issuing or dealing with the urgent applications that we normally say it's after hours might be of assistance. I did train some of the registrars that are there and how to deal with the visual hearing. And to them, it's a good thing to can do. It might even be saving them because they will be in a position to can connect from that Mutale area, and even some of the legal practitioners welcome the visual hearing system in that, find that some of counsel, or one of the matters that I heard, counsel was coming from Cape Town, there was one in Johannesburg, and I was in Polokwane, and we had successfully heard that the opposed application, and which was finalized at that very particular. Now, the other issue that which I intend to enhance is the Provincial Efficiency Enhancement Committee, which committee has been in existence, and I think even the JP Makova is chairing that because of the stakeholders that are there who ensure that justice is not only done, but must be seen to have been done. And if all these stakeholders, including the judiciary, we assist one another in that format, even when we digitalize the whole system, it might even be easier in that particular or service delivery and access to justice for all the litigants that which we, well, I normally say better strategies arise from the challenges that we have. It's not just going to be an easy task to do. There might be a number of challenges, but better strategies would then come up from that very particular point. I think I would pause here. I can't hear.
Sorry.
Thank you.
I'm going to ask you a question I asked the previous candidate, your colleague, Judge Ranyago, which impacts the transformation agenda we're all concerned with. That here we are with 3 male candidates for this position, and yet there is a female deputy judge president who was appointed to that court with the object, actually, was I was involved in those interviews. The vision was to have her take over from JP Makgoba at this moment, and now she has not even applied. Did you venture to find out what her position is, why she did not apply, and if did you seek to encourage her to do so?
Well, I had anticipated that she would apply because of the very principle as you indicate. But quite a number of legal practitioners and professional bodies at the time approached me to say, will you please make yourself available? Might probably be on a hearsay basis on this aspect, but then I was informed that they approached her and she declined. And the reasons that she finished, I'm afraid I can't at this point in time put on record because I haven't discussed that with her and I haven't verified whether those were correct. But all that I was saying is right. Was undated with calls and legal practitioners and other bodies knocking at my door to say, please make yourself available. I indicated to them succession plan that anticipated would be that she would take over the baton from Judge Makova, and in that way would ensure that the transformation is effected. Based on whatever that I've been informed, it is on that basis that I as well made myself available and put my name in the hat.
So you did not approach her?
Pardon?
You did not approach her? You did not speak to her?
No, I didn't speak to her pertaining to why she did not. All that we said was, we need to talk. In fact, we met by the corridor at Polokwane when I was at Polokwane. She says, Judge, I need to talk with you about something, but at this point in time, because I'm too busy, then we anticipated that we might find time in the Cape Town when we were having that conference, but better still, we did not have that time to speak about it.
All right. I omitted something quite important in your CV, which is your active involvement with the professional bodies there and the seeming passion you have for mentoring and training of aspirant lawyers and judges.
Yes, it is true that, well, from my membership of the Black Lawyers Association, a loyal member, I've gone through the ranks, and even during that time of my leadership as the BLA, in the BLA Association, would do quite a number of aspiring, quite a number of other legal practitioners to avail themselves to become judges. So we would motivate all our seniors to make themselves available at that very particular point. I've been in the then Petersburg Attorneys Association. In that association would be in the leadership of all the attorneys who are practicing in Polokwane, or Petersburg as it was then. And I deputized Judge President Makova for 2 years, and after that I took the baton from him, mentoring each other and guiding each other, and more of him guiding me on how to lead that association, which I took. I took the baton from him. Even with the Limpopo Law Society, which was the then second of the northern provinces, he was the councillor at that Limpopo, let me put it, now LPC, provincial LPC. And when he was asked by the BLA to step down, I'm the one who took the baton from him and became a councillor at that Limpopo Law Council. Being the judge, I became a judge in 2009, acting stints from 2007, and at the time, 2007, it was the time when members of the BLA were looking forward to elevate me to being the president of the association. But at that time, then they whispered, how are you going to become the president, whereas we are vying you or even encouraging you to go and be a judge. As we speak, you are an acting judge in Johannesburg. So from there on, it might be in Pretoria, and we are not looking forward for you coming back to the association to become the president, but be a judge. And indeed, blessed as I was, I then became the judge. But as a judge, I continued to serve the Black Lawyers Association by doing the judicial for aspirant judges, judicial training for aspirant judges, trial advocacy for the BLA, not only for the BLA, even for NADEL. We did even for the LSSA, we did even for the Law Society of the Northern Provinces then, now the Legal Practice Council of Pretoria. So today I was even sent a photo where we did the aspirant judicial training with the NADEL, and they gave me the photo on my phone. I looked at it, I was like, oh, it reminds me then of the services that I ran. But not only that, the aspirant judges, Mpumalanga, Gauteng, Limpopo, there was a time where the entire recess period, say for 1 week, would then be dealing with or doing this judicial training, starting with Gauteng, Mpumalanga, and Limpopo. We did that. I think Makoka J.A. now was one of the judges that I would always be with when we were doing the judicial training.
Yeah, he's also still very active in that regard.
Yes.
All right. Lastly, from me, at this stage at least, that division does not appear to be a happy one at all. It's not unusual for, disturbing, if not downright outlandish stories to come out of there. Accusations from practitioners against judges, and sometimes even judges against judges. And this view of mine is reinforced by something you've mentioned in your application form at page 26, where you refer to this cloud. Let me just read it quickly, and I want you to explain to us what it means. And after you've done that, tell us what you will do to ensure that there are normal relations there if you are appointed. You say a cloud of, in inverted commas, Limpopo division of the High Court Toyando is captured by certain legal practitioners, is hanging. The word capture insinuates corruption on the part of the bench of Limpopo division, Toyando, and I happen to be one of the judges who more often constitute a bench there. What's that? What does it mean?
Well, this matter, it started when the judge president came to, or convened a meeting, which he regarded as an urgent meeting. We went and attended his meeting in Toyando. There were the 4 of us, 3 judges and the JP. And he said that this division, or there's a complaint that this division, this court, is captured. And he elaborated about the capture, say, this division is captured. And the question that one inquired from was, when you say this division, are you saying all the judges here, or is it one judge who has been captured, and so on? He then responded, possibly by a Sotho proverb, but in short what it means is one rotten potato, it spoils others, meaning that it means all the judges in Toyando, we are all captured. And the rider to it was, all these people that which are saying captured are fighting me, the JP. They are fighting me in my personal capacity. And as a result, while they are fighting me in my personal capacity, I want you judges to go out there and show them that this is not what is going to happen, and show them that we are not going to accept it. Well, it's a pity at the time names of attorneys were mentioned. I'm not going to mention their names here.
No, you don't
I
have
think,
to.
Yes. And we had an appeal from the magistrates court. And one of the legal practitioners representing one of the litigants was one who the judge president mentioned with emphasis that such a person from that firm is one of those who are fighting him, and we must go out there and show them. When we went into court, Judge Makafala, Jay, and I, considering the words that they were said, and looking at the entire matter, we then said, we are not going to, that's the way as it transpired in court. Counsel, because we couldn't call them for, we are not going to deal with this appeal at this point in time. It's because of there is this cloud that is hanging. And if indeed there is an element of capture on one of us or all, it warrants the investigation. And most likely, because the judge president said it is a complaint and it's in writing. This is how he was doing and showing us that it's a written complaint. And we said, it's better for you, the attorney, to, or even us, let's wait for the investigations to be finalized. And as a result, we are not in a position to can deal with this appeal. We grappled with whether we struck the matter, or no, whether we recuse ourselves or we remove the matter from the roll. But at best we thought we can't recuse ourselves because we don't know who is implicated in this capture. At best, let's remove the matter from the roll, which we did, but the litigant was not happy about the removal because of the reasons that we advanced. They approached us with an application for leave to appeal. And again, we grappled, says, we can't give leave to appeal because if it is the leave to appeal of the entire matter, meaning that on the merits of the case, then they must go and seek leave by the SCA. But their submissions was no, based on your wording, meaning that we are now regarding you as the court of first instance with respect to the matter in issue of removal of the matter from the law and the reasons thereof. It is on those bases being persuaded to say we are sitting as a court of first instance, then granted leave or invited them. We then dealt with the application for leave to appeal and granted them leave to appeal to the Supreme Court of Appeal.
Which struck the matter of the roll.
Yes, it's a pity. It's a pity when it gets there. They argued the matter as if it was an appeal on the merits from the magistrate's court to us, and that's how it was struck off from the roll. I'm not saying it is correct or not correct, but I'm just saying the litigants themselves did not put it correctly. That is why I then put it here in the applications to say, because of this it is more likely to steer or say, but there is this issue. And I've noted that one of the professional bodies picked that up and say, how can a senior judge in Phatudi grant leave to appeal to the Supreme Court of Appeal, knowing very well what Section 16 of the Superior Court Act says? And it is on that context and that basis that I again say the circumstances that led to this impasse, it's there. Now the question is, what am I going to do to alleviate this problem? Firstly, if that application or if that complaint is no longer in existence, then it means it's the end of the matter. But if that complaint is still in existence, of which we haven't been even forward or afforded with that complaint, I don't even know who the legal practitioners are who are complaining about it. But be that as it may, there are reasons for us to say, because we find ourselves in between and betwixt. If we preside, we are captured. If we don't preside and we are against the litigant, yeah, then we are for the judge president, let's show them. And that in itself was an element, a thin line of, say, where are we? Now the question might be, we are still waiting for either the Judicial Service Commission, if that complaint has been lodged, to possibly invite us upon that. But to date, no such complaint has been sent to me. But if it is not there, then it is the end of the matter. Then we'll proceed to preside over the matters without fear, favor, or prejudice. Now, the other thing is, Judge President is retiring by the end of December this year. So it would mean that between now and December, that matter would be an end of itself by the end of December. It is on that basis.
Is the independence of judges in the Limpopo division at risk?
Pardon?
Is the independence of the Limpopo judges at risk?
If the complaint that it
No,
is...
quite apart from this complaint.
Okay. As of now, I cannot with certainty say they are at risk.
Okay. I'm going to allow my fellow commissioners to put questions to you, and we'll start with President Betze, who wants to follow up on something you just said now.
Yes.
Thank you, Deputy Chief Justice. Good afternoon, Judge Phatudi.
Good evening.
Was it the evening already? Yeah.
Yes.
Just a follow-up on this aspect. You say, in relation to this matter of Matamela and Mulaudzi, you granted leave to appeal to the SCA on the basis that in that matter you sat as a court of first instance.
Correct.
Did,
That was our understanding and my understanding that.
and leave to appeal was granted in relation to the order removing the matter from the roll or adjourning it.
Basically, it was for the reasons that which we had advanced. Yes, but in short, it was for that order.
But is that order appealable in the first place?
No, it isn't appealable.
And why then did you grant leave to appeal?
Because the litigant raised an issue of access to justice. And if the 3 judges in Thohoyandou are said to be involved or captured in that basis, how that the litigant says, how am I now going to be afforded an access to justice?
Couldn't the matter have been resolved by the simple expediency of getting a judge from another division to hear the matter?
Indeed so, but remember it was the issue of the judge president is the one who would have employed or invited another judge from another division.
And now the litigants had to incur costs, preparing a record, going to the SCA. The time of the SCA judges was taken up dealing with this matter, which should never have been referred to that court in the first place.
Yes, that is why I'm saying that it is based on the reasoning that we said that because of what is before us and because of the complaint as it stands, it means that all the judges that are in Thohoyandou are involved. And the litigant was more worried of the access to justice.
I'll leave it at that, but I'm far from being persuaded by your response. And I find it mind-boggling that you would grant leave in a matter such as this to the SCA. Thank you.
Thank you.
Mr. Chair, may I just follow up on that and then
All right.
close up about this judgment? Good evening, Judge.
Good evening.
What disturbs me about this matter is that the original matter involved the eviction of one of the litigants.
Correct.
And these are clearly not well-heeled litigants because the matter originated in the magistrate's court.
Correct.
And so you have an eviction order which has got dire consequences for that litigant.
Correct.
And the litigant is trying to appeal that order, and there's absolutely no recourse available to the litigant.
Yes. Remember, okay, sorry. I thought you were...
Yeah, and ultimately the litigant manages to get sufficient resources to take the matter all the way to the SCA. And even there, the SCA is compelled to strike the matter simply because the order that was granted is incomprehensible. And so, with great respect, Judge, I've got a difficulty where you say, well, the matter has now been finalized. It hasn't been finalized for these litigants because it's affected them in the most fundamental way.
Yes.
Can I just get your response to that? Just to the impact of all of this. I understand the situation at the Thohoyandou court, but I just really want to focus on the impact of all of this on this poor litigant.
Well, indeed, so we looked at that, and even the impact of this person being evicted, related as they may have been, the two of the parties, but the issue there, we were grappled with if we find ourselves on the wrong, if we are with, we'll then be finding ourselves to be complementing the complaint. But I understand that the litigants, because there's an order of eviction, and that person might find himself or herself on the street. We made the Judge President aware of it, of the judgment. He even arranged that an acting judge, together with the other judge, must then deal with the matter.
DCJ, I'll leave it there for now.
Commissioner Baloyi?
Thank you, DCJ. Good evening, Judge.
Good evening.
The issue about the allegations of whether it's an individual or many of you that are captured, you say, well, that issue is now over because nobody's laid a complaint. I don't know how you get to say it is over when there hasn't been an investigation of it. There hasn't been an outcome that certifies or that says there's nothing to the allegations.
No.
It seems to me you're still dealing with unresolved issues because there's no finality to it. And how do we get to say it is final, it is resolved and finalized?
Well, I never said it is resolved. I said if it is resolved,
Yes.
then it will be an end of the matter. That would have been in the event of going forward in the future. So I even said that we did not receive any complaint as yet from the Judicial Service Commission, and neither did we receive anything. So the investigation, if there is no longer a complaint, then it is the end of the matter. But if the investigation is still on, then we still await the complaint.
Can I just ask in a more pointed way? You accept the issue is still live? Do you accept that?
Yes.
All right. That's one. What is the consequence, or how does the JSC justify advising that you be appointed to the position of JP when there's still this open issue, this live issue of accusations, right? And without talking about the merits of it, there is an accusation, you admit and accept that it is still a live issue. How does the JSC rightly advise that you be appointed to the position?
No. Complaints are normally sent to us in terms of the provisions. Then if...
Can I, sorry, I'm good. Allow me, and I don't mean to be rude, allow me to interrupt you because of the hour of the day. My question is simply this. Can we, as the JSC, credibly advise the President to appoint someone in respect of whom there are unresolved allegations? And what message does that send to litigants in that court if the JSC advises the President to appoint someone who has an unresolved allegation over them?
Yes. Unresolved, but there is no formal complaint.
There is no formal complaint. You have accepted that the issue is live. And that, let's accept that. If the issue is live, it means it has not been put to bed, right? And I would have thought you would have an interest in it being put to bed, and so you would actively agitate that, let's bring this to an end because I don't want the cloud over my head. Well, that has not happened. You present as a candidate for position of Judge President, leader of the division, not just even a judge, but leader of the division. There is a cloud over you. How does the President appoint someone over whom there is a cloud? And a cloud that goes to the independence of the judiciary. It's not even that you're incompetent or anything. It is you are not an independent judge. That's what is being said about you. How does the President appoint someone like that? How do we recommend that to him?
Yes, that's why I'm trying to say that, because that is not a formal complaint. That's why I've always put it in quotes, to say it's a cloud, meaning that these are allegations, and these allegations, there is no formal complaint. and
I
we're-
understand
We're
that,
still
Judge.
waiting for that formal complaint to be lodged, and as I'm standing here, I'm sitting here, there is no such a complaint that has been
All right.
forwarded to me. That it was in that aspect that I said,
Yes,
if there
understand.
isn't any formal complaint that has been lodged,
Okay.
then it means that in code cloud might be taken to be say there is nothing.
All right. I note your answer and accept that is how you're answering. A different question from me. You have been nominated, you have quite a number of people that have nominated you. One of them is the mayor of Vembe municipality.
Correct.
So you've been nominated by a politician. Is it an unfair comment to make that it may display a lack of judgment on your part that you are nominated by a politician of a body, one, firstly, it's a politician, two, it's a body that likely litigates in your court, right? Why should the public that litigates against the Vembe municipality have confidence when you sit in a matter, have confidence that you will be fair, you will not be biased because they are litigating against someone who nominated you to appointment? Isn't that a fair concern to express? And I express it from the perspective of a litigant, but also more importantly, doesn't that perhaps display a lack of judgment on your part about the appropriateness of that?
Well, when I received that nomination, it is one of the issues I said, why are you nominating me? The reasons advanced was that I assisted when administering the oath of councillors. There was an aspect where the oath that which they were taking lacked an element of uphold the Constitution of the Republic of South Africa. And based on that, I then indicated I'm not comfortable to stand here and administer an oath of this nature where the terminology uphold the Constitution of the Republic is lacking. And they expressed a view to say that it's for the first time that they find a judge of my integrity, and as such, they would love to appoint me as one. But being as a judge, we preside over matters without fear, favor, or prejudice. Even as litigants that they might be coming, all their matters that might be coming before court will be presided over without fear, favor, or prejudice.
All right, may I please interrupt you, Judge, just so that I get a straight answer from you? Is your answer that you see nothing wrong in the fact that you've been nominated by this person or this entity as I've described it? The answer, it's a yes or no.
Well, can I put it differently to say that I've been persuaded to accept their nomination.
Okay, can I say this to you, that I take it your answer is, this is what I take from you. It's you say there's nothing wrong in you being nominated this way.
Well, I looked,
That's what I'm reading from you.
I looked at it because it's not that it's from the ANC or the EFF political party per se.
Okay, thank you. Thank you, DCJ.
Judge President Makgoba.
Thank you, DCJ. Good afternoon, Judge Phatudi.
Good afternoon, JP.
Judge Phatudi, you will note from the comments of the law bodies, in particular, our Society of Advocates, that side, who are practitioners daily in our courts. Now, the outcry is that you lack sufficient working knowledge of the law. That's their outcry. They say, irrespective of the number of years you have been sitting as a judge, you still lack the sufficient working knowledge. Speaking for myself, I would not crucify you on the lack of knowledge of the law per se, because even the most of the celebrated judges do err. But my concern would be with regard to the controversial nature of the judgment you deliver and the orders you issue at one stage. Then I'll give examples with regard to one or two cases just to highlight that. If you refer to the case of, this case even went to the Supreme Court of Appeal. It's a judgment dated at the Supreme Court of Appeal was on the 14th of October 2019. The case of NW Civil Contractor CC versus Anton Romano Incorporated and Sheriff of Toando. Now, you'll recall that in this matter, you made an order that a particular judgment in which a certain attorney was involved as an attorney of record there, that judgment you declared it null and void, invalid, on the basis that that attorney at some point, though he was an admitted attorney, at some point, a particular period, he practiced without a fidelity fund certificate. Right. That was your order. You said the judgment is invalid. Now, in the light of that judgment, that order, there was a scramble among the attorneys in that area of Toando. They went to go and search whatever judgment that attorney got involved in as an attorney of record in order to bring them forth. Apparently, they needed those judgments also to be declared null and void, depending on whether such orders would be in their favor or not. Then, when I realized that as a judge president, when I heard about that, I acted immediately and issued a directive, a written directive to all the legal practitioners to say, good people, please do not take those steps to go and take matters before that the judge go and declare them null and void. More so that the respondent in that matter has petitioned the Supreme Court of Appeal for appeal, since you had already dismissed the application for leave to appeal. I made that request to the legal practice by way of a written directive. And in that directive, I emphasize that that order you issued had very serious repercussions. One, it means that all the parties whom that attorney represented, if it is a divorce matter, then the parties then become remarried. Secondly, if it was a matter where the road accident fund has paid out so many million to a particular individual, the judgment is invalid, the order is invalid, must refund. If it was a criminal matter, the accused has been acquitted, he must be tried de novo. So I can go on and on and on. Then I had to stop that. Now, instead of I getting cooperation, that let's leave this matter to go on appeal, then we'll get the end result. Then I was a victim of circumstances. Then I was accused of interfering with the independence of the judge. Apparently, they were referring to you that I interfered with, but I feel I was not interfering. I had a duty to perform in this as a judge president. Be that as it may, your order was set aside by the Supreme Court of Appeal. Now, at the end of the day, can you see how controversial certain orders can be, or judgment and orders can be? That you were wrong in declaring a judgment null and void by virtue of the fact that the attorney of record practiced without a Phatudi fund certificate at a particular point, although he remained a duly admitted attorney. So we have to, just to comment on this controversial nature of the judgment and the order. Thank you.
Thank you, JP. This matter, indeed, when it was then issued, we communicated between the two, and you even indicated, as you stipulate, the consequences thereof, which I accepted before you, which I said, I have no problem with the manner in which you have interfered with the matter. But now, the issue of being reported, I am not the one who reported the matter. Could have been somebody who, after seeing that your directive, took upon himself, without my instructions, without me participating in it, and lodged a complaint, which you called me, JP, and showed me the complaint. I even informed you I am not part of that complaint. So on that aspect of the matter being taken as a complaint, I never participated in it. I indicated to you that, in fact, even the very person who took this matter or reported this matter applied for my recusal in all his matters. We even shared amongst ourselves the circumstances that which the relationship is. And in my view, I thought with the Judge President, it was water under the bridge. We have settled that issue, and that would be it. Perhaps, cutting long story short, there might be a say to say that a good judgment, not as in written judgment, but a good judgment is an experience from a bad judgment, meaning that we learn from our mistakes, we go on and say, hey, I've bent my fingers here, and let me go on. Because of that, it's an experience, and in the future, a good judgment would then follow based on that. Thank you.
Thank you. Further question. As the Judge President, you are called upon to lead by example on matters of law and procedure at your court. And when it comes to matters of appeal, you must be able to know which matters are appealable and not appealable. You must be able to know whether the High Court has the power, the jurisdiction to grant leave to appeal, or is any issue where the Supreme Court of Appeal should grant a special leave and so on. Now, as you told, I want you to appreciate the provision of Section 16(1)(b) of the Superior Courts Act, which says that, which provides that an appeal against any decision of a division on appeal to it lies to the Supreme Court of Appeal upon such leave having been granted by the Supreme Court of Appeal. Clear as all that. Now, in the matter of Matamela and Mlaudzi, which fellow commissioners have just raised in passing earlier on, in this matter, first and foremost, the order was a removal of the appeal from the roll. This surely the order was not appealable at all. Secondly, you said with Judge Makavula, the legal representative approached you sitting as, mind you, as a court of appeal from the decision of a lower court. Then they came to you on application for leave to appeal. Then you granted leave to appeal against the provisions of Section 16(1)(b), because You had no, but because you were sitting as a court appeal from the decision of the lower court. So this, what I appreciate, that a working knowledge of especially procedural law as a judge, but it's very, very important. As a JP, you are going to be the person who are going to draw up the appeal rolls. You must know which matters you put on the roll and which do not belong to the roll, and so on. Your comment on the lack of this sufficient working knowledge of the law, your comment on this?
Well, the provisions of Section 16, I think I've already elaborated on it, but if 3 judges preside over the matter as the court of first instance, then...
Sorry, I'm sorry to interrupt you. I'm not talking about, a full court sitting as a court of first instance, please. I'm talking about you and Judge Makafala sitting as a court of appeal on a decision of the lower court. Let's just confine ourselves to that, please. Thank you.
Yes, as I indicated, that I've already indicated the circumstances upon which we then set on that matter, which I've elaborated earlier on. DCJ, I don't know if must I repeat myself on that aspect again.
If you feel you've answered the question, then that's all you need to say, and that's that.
That's why I say I thought I've answered that question when we were dealing with it earlier on. But if the time say the understanding of Section 16 would be say, if 3 judges are sitting as the court of first instance, then any litigant who seeks leave must first obtain leave from the said judges, because they were sitting as the court of first instance.
That is his answer, JP. You take it or you leave it. No, Commissioner Nunes?
I just, good afternoon, Justice.
Good afternoon.
Yeah, look, I just want one quick question. In your view, what are the basic qualifying requirements for one to be a judge president? For you to be a judge president, what is it that you must possess?
The qualities
TCJ.
of...
Look,
TCJ,
sorry,
TCJ, is Nyambi this side.
Yes, Commissioner Nyambi?
I think you forgot the representative of the Premier before we can get us to
Oh,
forward.
I'm sorry, Advocate Singh. Thank you so much for that reminder. It's been a long day. I'm tired, I must confess. Please forgive me, Advocate Singh. You may put your question.
yeah, because I've already answered this question.
Stop
Can we-
right there, Commissioner Nunes. We'll catch up with you later.
I'll come back after him.
Yes.
Thank you, DCJ. I think I'm going to take over your question because I think our questions are overlapping, so you get the answer. Thank you. Judge Phatudi, good afternoon, sir.
Good afternoon.
Okay, you've interviewed, I think this is the 4th time now we sit together in an interview. You interviewed for the position of Judge President in 2015. You've interviewed for the position of Deputy Judge President in 2017. You've interviewed for the position of Deputy Judge President in 2019. And now you interview for the position of Judge President in 2022.
That's correct.
Judge, in all these interviews, there were shortcomings in the requisite level of knowledge and leadership skills required for the positions. It's now 3 years after the last interview, and given the discussions that have taken place thus far, do you feel like you have acquired the knowledge and leadership skills expected of a Judge President?
Yes, I do possess that, Mr. Singh. This will be it's a leadership position. And as I indicated that I have a vision, and that vision is in me, it's with me. And if or when appointed, then that vision will be implemented to the betterment of the citizens of Limpopo. Members of the community of Limpopo really need some justice. As I indicated, that there are quite a number of matters, the backlog of matters, and imagine waiting for 2 years or a year for a matter to be heard. Litigants want their matters to be heard and to be finalized as speedily as it is reasonably possible. The way as the role is at, and for what we have in the Limpopo division, that is exactly what I am of the view that with the vision that I have, I might be or I will be in a position to bring back the backlog and deal with the backlog and satisfy the members of the community in dispensing justice.
Thank you, Justice, and thank you, Deputy Chief Justice. That's my question.
Is it a follow-up, Commissioner Malam? Okay, Commissioner Nokes?
Thank you, TCJ. I've already greeted you, Judge. It will be just a question following from what Mr. Singh is asking.
Okay.
Now we have 3 judgments that are in question. The judgment that you are referred to by the JP, the order where you granted an appeal in respect of a removal of the matter, and you applied to be a judge president. Would you say in your own, would you say as of now, right now, do you have the necessary judicial leadership that you can provide in that division?
Yes, I do have the qualities of a leadership and to take leadership of that province. As I indicated, that I've got a vision, and that vision, that which I intend implementing, would then display the leadership qualities that I have. I've been the chairperson of Polokwane Attorneys Association. I've been the chairperson of Limpopo Law Council, LPC. and-
Sorry, Judge Phatudi. He asked about judicial
Yes.
leadership, not leadership you may have practiced
Oh.
in the professional bodies or elsewhere.
Yes. Thank you, DCJ. Yes, the qualities that I have. I've acted as the acting deputy judge president.
Now, look, let me ask this.
Okay.
You have 9, how many say, 9 judges in your division.
Correct.
In relation to those judges, can you intellectually lead that division? Meaning that if there is a case, I'll make an example, I'm trying to simplify this. If there's a case, a public interest case or a complex case, where you take charge, you are the one who must give direction in that division. Do they respect you? Do they regard you as their leader intellectually?
I would say yes, they do respect me. The other judges that I'm with at that division.
Okay. Last, are you captured? Are you a captured judge?
No, I'm not captured. And I'll never allow to be captured.
No, thank you very much, DCJ and Judge. I think you are captured because you see nothing wrong with being nominated by a politician. And your answer is that it's not from EFF or ANC and all that. The mayor is from ANC. He's not from SCO or some church or anything. He's from ANC, and you see nothing wrong with that. And you say a politician is a person who comes from EFF, ANC, whatever. You know, when you fill up forms and were asked, what do you do for a living? And you are a chairperson of a branch of a political party and you are not employed. You can't tick politician. You take unemployed. You become a politician once you assume an office of politicians. So why would a judge who's not captured not see anything wrong with being nominated by a politician, irrespective of that where that politician comes from, and still do not want to disassociate yourself with such a nomination and speak so proudly about it that they said I've inserted something and therefore I'm very proud. They are very proud of me, and then politicians can nominate you. That's what a capture is about. Capture is not money. It is these types of things, whether you say no or you don't say no, but for a fact that you have been nominated by a mayor who belongs to the ANC, who's a politician. The leadership of the EFF or any other party in that province has got a right to say, remember, that is that one who was nominated by ANC mayor. That's going to be your definition in that province going forward. Because even sitting here, you get an opportunity to disassociate yourself from that. No, you are justifying it. That's what I'm going to argue in the deliberations, that you are captured by politicians because you are even unable to disassociate yourself from them, and you even speak proudly of how they are not politicians because they are mayors and they are not from the political parties. That guy, when he fills, I don't know if he's a guy or a lady, when he fills up a form, they asked that person if he is a PEP, and he declares he's a PEP. But a branch secretary will not do that because he occupies no official political office. Doesn't this demonstrate that your lack of judgment as a judge who applies for a senior position in that province?
Well, that is not the way as I saw it, but your emphasis in the matter would then possibly might be saying that that nomination might be expunged from my record.
No, but now it should be clear. Are you asking us to expunge that politician's nomination from your nomination so that when we leave here, we don't regard that?
Yes, let it be expunged from the record.
Thank you, DCJ.
Thank you, DCJ. Good evening, Judge Phatudi.
Good evening, Commissioner.
How are you?
Fine, yes, sir.
Judge Phatudi, I think you've seen the objections from different legal bodies. I want to hear you on this one from PLPA, where they are saying you have shown no interest in the profession and that you have on numerous occasions been biased in matters before you. What is your answer on that one?
So that's of the Polokwane legal practitioners.
Yes.
Specifically, which number are we referring to?
It's the one that says you have lost, you have shown no interest in the profession and that you have on numerous occasions displayed bias in matters before you.
Well, I don't know which matters they are referring to, but I have always shown the interest in the legal profession. I've demonstrated by engaging or even participating in the aspirant judicial training. And in that aspect, I think you as well can bear testimony that when we were at, I think it's in Mpumalanga, you were one of the aspirant judges who attended the said course. And I've expressed my willingness of assisting, of sharing the skill that I have with the members of the profession. And it is on that basis that I don't know which matters are they saying that I've shown to have been biased.
Okay. My second question to you, we are sitting with a problem here where there's no woman who is the head of court.
Correct.
And out from Limpopo, we've got 3 males who are applying for that position.
Correct.
Again, out of when you were outlining your vision,
Yes.
I didn't hear you saying anything about how are you going to assist in creating a pool of women who will be judges in future.
Indeed, it might have been an omission in dealing with that, but that would be the first priority. One, that the demographics of judges there in Limpopo are lacking of the appointment of a woman. As we speak, when appointed as the JP, there will be 2 vacancies created. Judge Homu is retiring day after tomorrow. That is his last day, on Friday. And the vacancy is created because of that. When appointed as the JP, another vacancy is created, which might be likely to be, or not likely, but priority would be given for the appointment of women and for the demographics of that division to be at par with what democracy dictates.
Thank you, Judge Phatudi. Thank you, DCJ.
Thank you very much, Deputy Chief Justice. Good evening, Judge.
Oh, good evening.
Normally I would want to talk to you about the law, but there's a law that has been said which really triggered my interest in relation to your vision. At the start of the interview, you were probed whether you had a conversation with the current Deputy Judge President, and you said, no, we met in a corridor and we said we could get time, and then perhaps we thought we'll go to another conference, we'll get time, but eventually you did not speak to him. And then you went on and said, and you correct me if I heard you correctly, that between the 3 divisions, you'll want to be a present Judge President and be there at least once a week. Did I? Then this brings me to the question that I have. I'm just wondering as to, because if you are a Judge President, I would believe that you form a leadership group with the Deputy Judge President and some of the senior judges. What role will the current Deputy Judge President play in relation to your vision? Or are you going to be the overpowering Judge President who wants to be in each and every, because the way I understood it, because I don't know Limpopo quite well, you're talking about, it seems like there's a distance between the different divisions. So that means in a week, you'll be traveling a lot between these divisions. And I worry as to what then is the role of the Deputy Judge President in your vision.
Well, the vision that I have is the vision for the division. It's the vision that I would inculcate in all the judges to have that vision as well. That we dispense justice, we then deal with matters expeditiously. when I'm saying I would be in all, the Deputy Judge President would be at one of the divisions. And once we are rotating, she might as well, or will be on a rotational basis, both going on around the said division. Meaning that not only me, but there will be a rotational policy that judges we must rotate, like as now there are terms that which the Judge President would rotate us and say, this term be in Polokwane, this term be in Thohoyandou, and so on.
Oh, not every week?
No, not every,
Okay.
all I was just saying is that just to be visible.
Okay. Thank you very much, Deputy Chief Justice.
Thank you, Commissioner. Any further questions, colleagues?
Yes, DCJ, if I may.
Okay, it was Commissioner Makonisha first, then you follow.
No, thank you very much, DCJ. Good evening, Judge Phatudi.
Good evening, Commissioner.
Just one question. There's an objection that is being raised that you lack collegiality. Is it true?
It is not true. It is not true because we communicate with the judges, we communicate with one another. It might be by WhatsApp. Remember, there are those who are in Polokwane, those who are in Thohoyandou. Most of the time, I'll be in Thohoyandou. But given a chance of being in Polokwane, I'm collegial with the judges there. We at times communicate via WhatsApps. If there's any issue that needs to be discussed, we normally do discuss on face-to-face basis, especially when there is an appeal that which we are dealing with. To show that there is collegiality, even today with my colleague, Judge Khanyago, we've been together in the holding, I called it a holding cell, where we were seated there, we were talking, we wished each other good luck with these interviews. So it is not true that there is no collegiality amongst us.
Thank you very much, DCJ.
Commissioner Nkaito?
Thank you, DCJ. Judge, I just have two questions to ask you. I mean, you would accept, no doubt, that the constitution that we have in this country is transformative.
Correct.
And you would accept that it is not self-executing. It's executed through laws in parliament, but primarily it's executed through judicial outcomes and judicial decisions.
Correct.
And that judges are at the coalface of that implementation of the constitution.
Correct, yes.
Now, the reason I'm asking you this is to lay a foundation to just go back to that SCA judgment, the one that was struck from the roll because you exercise jurisdiction that you don't have together with the Judge Makaful.
Yes.
In paragraph 2 of that judgment, this is how they describe the matrix of fact. You have it in front of you.
That should be paged here.
Now, in paragraph 2, they say the origin of the appeal before us emanates from a judgment of the Thohoyandou Magistrates Court. And then this is what worried me, which ordered the eviction of the appellant from the immovable property of the respondent. So someone had lost a house in front of you or a place of residence.
Yes, there was a dispute over the property.
Yes, but yes, there was an eviction order. Someone had been told to leave a place of residence. Correct?
Correct. Yes.
Now that implicates Section 26 of the Constitution. Correct?
Correct, yes.
Now what you do as a court of appeal, this is what the order says. The High Court So the appeal against that order served before the High Court on 18 September 2022. So in front of you and Judge Makafula, there is an order of someone who has lost a house and therefore their rights to Section 26 are implicated. What you do instead, the High Court removed the matter from the roll. You don't deal with the eviction. You remove the case from the roll.
Correct.
And yet, the very purpose of having a judiciary is so that it can protect people whose properties are being taken unlawfully. Now, the other thing that worries me greatly with this judgment is they then say, if you go further down in the ruling of the SCA, I think go to paragraph sorry, I just want to go back to this paragraph. Unfortunately, I can't mark it from my computer, but there's a second issue of this judgment that really worries me. Yes, paragraph 4. You have paragraph 4.
Yes.
It says here, on 25 September 2020, the appellant requested reasons for the order in terms of Rule 49 1B. Now, that's the appellant from your division after you had struck his appeal over an eviction. That is the person who asked for reasons. Correct?
Yes, correct.
Now, and then it says, to date, no reasons were forthcoming. I mean, that's between September and March in an eviction case, which you have struck from the roll, but to give no reasons.
We gave reasons.
Yes, but
Commissioner.
it says, so the SCA is not telling the truth when it says, no, to date, no reasons have been given.
Well, that's why I say we gave reasons, but because it's not even captured there, I don't know what happened to those reasons, but we did finish the reasons.
But the reasons were not in the record of the SCA.
Correct, but isn't it the litigants are the ones who are preparing the record, and they are the ones who make it a point that the said reasons are.
But you gave reasons, there are two rulings you made. The one was to strike the application, the other was to grant leave to appeal. Which reasons did you give?
The reasons for the removal of the matter.
So where are those reasons?
We granted the reasons, we gave that to the litigants.
All right, well, I would like to see those reasons here. And for your granting of your leave to appeal, did you give reasons?
Yes, we gave reasons as well.
So you've got two sets of reasons?
Yes.
Which are not part of this, but they exist somewhere?
No. With respect, the reasons for the leave to appeal, I think they've referred that to. Remember, once the matter is before the SCA and they find, otherwise there's no way in which we as judges can inform the judges at the SCA to say, these are the said reasons that you say we haven't forwarded.
Yes, no, I appreciate that. I'm just talking about your application here. When you know that this is an issue and you know that there is a finding that you never gave reasons for your removal of an eviction case from the roll, but you didn't provide those to the JSC. That's my point.
Well, I didn't anticipate that those reasons would be needed here.
Now, yes, then the other thing that worries me is the letter from Advocate William Mukare, who is objecting to your application, who says that when you first applied, there was an objection, but they did not think that it was too much of a problem because it was too early in your career. They now say 10 years after you've been on the bench, you have not acquired enough grasp of the law. Now, you may or may not be made a judge president, I don't know. But if you are not made a judge president, you still have another 9 years on the bench. And you have been there for 13 years, plus 12 years as an attorney or an advocate, I can't remember now.
Attorney.
If in this collective period of 23 years, the chairman of the Limpopo Bar says that you cannot write judgments, is there anything you're going to do about that, or you just going to carry on as usual?
Well, there might be the judicial training if there is a need for the upping of the said judgment writing, but the way as things are, ironically, it is the bar that approached me to say, make yourself available.
I understand that, but there's clearly a view that is prevalent, not just by Mr. Mukari, but many other complaints against you. The complaint is you are unable to write coherent judgments. It worries me because you are applying to be the head of the division. Really, really, it does worry me that you are trying to become the leader of the division, but the bar that appears in front of you every day says you cannot write judgments.
I can write judgments. I write judgments. They are there. It is the professional body that approached me to make myself available, and ironically, the manner in which they put it, it's quite different. The group that nominated me is part of the Limpopo Society of Advocates, because the Limpopo Society of Advocates has 5 groups.
All right, so from your perspective, nothing will change?
We learn every day. The experience that we gain does make one to change. The judgment that I've written day before yesterday might not be the same as the judgment that I'll be writing probably in the forthcoming week or so. As I indicated, that at times a good work is an experience from probably a bad experience, but that it makes and it sharpens one to be a good judgment writer.
Yes, just the last point, DCJ, if you don't mind. I mean, my first point, which was your apparent indifference to eviction cases that implicate Section 26. Are you going to do anything about that?
It's a judgment, it's matter, it's gone. I'm functus officio now, unless if it comes back again. But as of now, that matter, it's not before me, and it's out of me.
Just a quick follow-up, DCJ. Judge, when Advocate Mugai Toby spoke about judgment writing and that they say you can't write judgment, what are you going to do about it? Did I hear you saying that if there is a need for going to judgment writing, such things can be considered? Did you say that?
I'm saying that as and when we attend these seminars, as and when we attend the workshops, that themselves will up the skills of one in doing that. That's why I even said that a judgment that I may have written yesterday might far be different from the one that I might be writing the next week or so.
No, I want to understand that we're going to have a JP who's going to be attending judgment writing.
No.
Oh, okay.
Follow up, DCJ?
Yes.
Judge, I think Advocate Ngatobi asked you a very important question. And I'm not sure if you, or maybe I misunderstood his question, but if it was not his question, then it will be my question. And I'm not going to use the word indifference. I'm going to say the apparent lack of care in eviction matters that implicate Section 26. We are not talking about the one that is gone and dusted.
Okay.
When those matters come before you, what will then be your approach?
It will be to deal with those matters expeditiously, taking into account the right that is entrenched in there.
Thank you, DCJ.
No, sorry, I'm sorry. I have to follow on this question from the professor. You know,
Let us not flog
yes. Yeah, I'll take your guidance, DCJ. I won't say anything more.
Thank you, DCJ. Judge Phatudi, there's one of your judgments that I feel compelled to deal with simply because it has garnered in the past a fair amount of attention. Can I ask you to open up your application and specifically section 16.1.4, where you deal with the shy decision?
I'm sorry, I'm just trying to...
It's 16.1.4. It's paginated page 23.
Page 23. of the paginated record.
Yeah, look at the handwritten numbers at the bottom of, and just look at 23.
What is it?
Do you see you list as one of your significant cases the shy decision?
No. Okay. Just a minute. Shy.
Do you have a Judge Phatudi?
Yes, 16.1.
16.1.4, you list your shy decision. In your application.
This is not mine. This is not mine. 16? Yes. 16.3. 16 point?
16.1.4.
Yes.
At page 24.
So, I just want to be clear that the matter you refer to here, you indicate that it is significant because you found that an apology from the complainant's family member an apology to the complainant's family member who wholeheartedly accepted the apology from the accused. You found it as tipping the scales more to substantial and compelling circumstances that warrant deviation from the imposition of the prescribed minimum sentence. Is that what you say there?
That's what we said in the judgment.
Yes, no, I'm not worried about the judgment. I'm worried about why you're saying it's significant. You're saying it's because of that. Because you found that the accused had apologized to the complainant's mother.
Yes.
And the complainant's mother testified that they accepted that apology.
Yes.
And you took that into account as a mitigating factor.
We took that as a mitigating factor. Yes.
Now, this complainant is 13 years old.
Yes.
Correct?
Yes, he was 13-year-old and raped by cousin brother.
Yes. So you have a 13-year-old girl whose mother testifies that she accepts the apology of the rapist.
Yes, the mother of the victim accepted wholeheartedly to say that this is my nephew, and I accept wholly and should not be sentenced to imprisonment for life because he's still young.
So you accept the apology from, the mother of the complainant, of the 13-year-old girl, accepts the apology from the rapist, and you take that as a mitigating factor in deciding the sentence.
Of the mother accepting the
Yes.
apology.
The mother accepts the apology, not the 13-year-old. The mother accepts the apology.
Mother,
And you use that as a mitigating factor.
correct. That's what happened.
And you believe that that's a sound principle.
The circumstances that prevailed at that and the testimony by the mother, because it's a family issue, and to a point where she even said that they were kind of like playing hide and seek, and based on that, I accept the apology, and even saying that let him be not be punished or sentenced to imprisonment for life.
DCJ, I have no further questions.
All right, thank you.
What follow-up,
Commissioner
DCJ?
Nugaitobi-
Follow-up, quick
All right.
follow-up. What is a family matter here? A rape is a family matter. A reported statutory rape, it's a family matter. Is that what you are saying?
What I was saying is that the victim and the complainant, that the complainant and the accused are family members. It's an uncle to a daughter, and the mother will say, this is one of the person I'm responsible in taking care of.
But
And he's still young.
what does that account for? Because rape victims are raped by their family members. So it makes it easy and acceptable if it's uncle to a nephew and the mother says, this is my uncle. And most probably that uncle is one of the providers and the mother can't go against. And you come and say that is an acceptable principle you applied. Judge.
Well, at the time when presided over the matter, those are the facts that which were presented and one was persuaded of. Yes, it is gender-based violence. It is a serious offense, and it is on that basis that it might have been, but that was in 20, which was even reported in the blue books.
Thank you, DCG.
Colleagues, there must come a time when we stop interviewing this candidate, because it's clear that we can go all night. Commissioner Nugaitobi, I'm going to give you a chance to put the question you wanted to put if you still want to. And
No,
then-
definitely not,
Fine.
DCJ. Yes, thank you.
Right. Commissioner Bredenbach, do you have a question for the candidate?
Commissioner Barnard doesn't
Did I
have
say
any
Bredenbach
questions.
again? You must, well, when I say Bredenbach, you must just know I'm referring to you until she's back.
I thought that might be a signal that I mustn't ask a question.
Judge Phatudi, thank you so much for presenting yourself for this interview. You are excused. Oh, I wish you a happy birthday on Saturday. You share a birthday with my favorite son, and he's a good boy.
Yeah. Thank you very much, DCJ.